Actually, on me, you know, Black had warned me. When I went down to interview for the clerkship, I was at the Harvard Law School that year, and I got this letter from Black along about February, who says kind of a non-committally, if you're interested, I'd be glad to talk to you at some point. Well, I took that to mean, if I'm interested in this clerkship, I better go. And I was right. Because I got there, when I sat down with him, almost the first thing he said is, before you came down here today, I'd already decided to take you. Well, I think if I'd not gone,
right,
I wouldn't have gotten it. That's my interpretation of that. So, the conversation he told me, he said, this was before Brown won, about, what, 2 months, 3 months before that. He said, you know, there are going to be some very contentious, controversial race cases coming along, you know, and there's going to be a lot of backlash and so on. He said, I don't know whether you really would be wise to take this position if you plan to go back to Alabama. And my recollection of what I said is, well, you know, I'll just take my chances on that. You know, I mean, I was well aware of that. He didn't have to tell me.
This was in the summer of 1954, post Brown versus Board 1, and whether or not there was even conversation about what just had occurred on May 17, 1954.
I just don't recall any Brown discussion among that group, and certainly there wasn't any with Black at all. Hadn't been the year before either with his clerks. Total silence. The case might well not have existed, as far I put it that way. The next event about it came in April when the arguments took place. It was scheduled for December, but because of Jackson's death, they were put over until his replacement could arrive. And Holland was confirmed, as I recall, about mid-March. And the argument took place around the middle of April. As I recall, there were about 3 days of arguments. And that's the first time I really encountered the Brown case. I sat in on all the arguments and heard them in the courtroom. But again, no discussion with Black about it. I mean, he knew I was sitting in on the arguments. I was in the courtroom when the opinion was handed down. And I went back around to his chambers, and he was there shortly. And I had noticed one thing, which I later went back and verified in the written opinion was correct, that in the opinion, Warren uses the term discrimination numerous times, maybe 6 or 7 times, just talk about discrimination or racial discrimination, et cetera, et cetera. And I said to Black, I noticed he used the term discrimination many times. Never did he use the word segregation or desegregation. And I was a little curious about that. So I said this to Black. He just smiled and said, well, I think they'll understand what we mean. They was a big word with Black. They was the rest of the world out there who, in his view, would avidly read these opinions and think about them. there were letters coming in, most of them very hostile and critical. I remember one I distinctly remember, not so much about Black, but I happen to remember this one. About a month after Jackson died, there came a postcard one day that said, 1 down, 8 to go, you can't win with the Lord at the wheel. During my time in the law school, I was there 4 years as dean, that Justice Black was resurrected in Alabama. He had been persona non grata, absolutely, up until about then. And I sort of helped that effort along. They invited him to the annual meeting of the Alabama State Bar. I think it was in the summer of '67. I'd been there about a year. And I set up, and the meeting was in Tuscaloosa where the law school is, and so I set up a big law school event in connection with that, alumni gathering and so on, a huge kind of luncheon and so on, where he spoke and all that in the law school. And that was his re-entry into the state. And it went over very, very well, and about 2 years later, about a year after Warren Burger had been appointed Chief Justice, he and Black came together to a meeting of the Alabama State Bar in Birmingham. And that was a big deal. Huge attendance at that meeting where they both appeared and spoke. And it was clear then that Black had been re-accepted into Alabama during my time there as dean. I arrived there, as I say, in August. I saw Jackson only once. I remember I was in my office there with the door open onto the corridor, and here comes Jackson walking along the corridor, heading toward the conference room. And he's walking slowly along by himself, and there he was. I saw him. He was in view maybe 10 or 15 seconds or so, and that was the only time I ever saw Jackson. He was dead within another week or 10 days after that. And the clerks, we all went in a body to his funeral in National Cathedral. My recollection is we sat as a group in the balcony of the north transept of National Cathedral for the funeral service. And of course the entire court went to Jamestown. So Black was gone after that for 2 or 3 days. My impression about that, I sort of picked up by little drips and drabs sort of, is that the hard feelings like that seem to have diminished to me a lot. One day, Jackson was in Black's office one day when I was in the room next door. I didn't see him and didn't hear it, of course, but the secretary said Justice Jackson's in there and so on, and because I didn't go in. But she had some comments. She seemed to think that they were getting along quite well, and sort of his general attitude about it when they did mention his name maybe a couple of times. So my impression was that the worst of that was sort of behind them. Yeah. There weren't any real hard, bitter feelings continuing.
When you were there, Justice Black had the close relationship with whom?
Oh, probably Douglas, although that wasn't, that was a little strained, I thought. He highly disapproved of Douglas's private life. You could tell he didn't like that. And they weren't that close, I don't think, ideologically, so to speaking. I think they've always been kind of linked, and they were together on a lot of opinions and one thing or another. But I recall hearing Douglas maybe being in Black's office a couple of times during the year, but there was not a lot of back and forth thing. A feeling that their relationship was a little distant and cool, certainly not warm personally, as far as I could tell.
What about Frankfurter?
Well, Frankfurter and Black always seemed to be in a contentious posture in relation to each other. And they had such different views about various things, and Black would, I remember one day, we had, as I mentioned, the clerks had this private dining room downstairs, and one of the things we did, we would have speakers in from time to time. Anyway, the day Frankfurter came to lunch, it was the longest lunch by odd we ever had. It lasted about 3 hours. And what he did is, he said, as the lunch was winding down, I would go around the table and have each one of you ask me a question, and then I'll answer them. So we were around the table. He got 18 questions. All that. Then he started over, and miraculously, he answered each one of them. He addressed each question. And this went on, as I say, for about 3 hours. So he finally got back up to the chambers, and the first thing Black said, well, is school over? He often would make comment. He said, Felix says he has to struggle very hard to disguise his bias in favor of labor. And he says he's very successful at it because I never detected any. Well, one thing I'm sure about, given Brown 1, I think what they did in Brown 2 was right. That I have no question about that. Black said, and I mentioned a moment ago, there were a few comments about the case after it was over. Black told me, well, I've heard him say a couple of things about it. One was that his greatest apprehension about the result of this case was that judges all over the South would be entering injunctions, and they'd be bringing people up, school board members and others, up to hold them in contempt and trying without jury. That was it. He believed, contrary to what the existing law is, that in a criminal contempt charge, a person had a right to trial by jury. And he foresaw that there might be a lot of that going on, violating what he considered a right to trial by jury. Now, all that didn't happen, I don't think, but he told me that was his main apprehension about it, that it would.
That's very interesting. So he saw it as an incorporation controversy almost.
Yeah, well, a potential out there, yeah. He also had said that, and this was a conversation I had with him 2 or 3 years later, not at the time. Looking back, he thought that they should have entered an immediate decree that the plaintiffs, the parties to the cases, be admitted to school on a non-segregated basis, that they should have ordered immediate admission on a non-segregated basis. He thought it was a mistake not to have done that.